Good afternoon, my name is Vasil Tarasenko. I have been a lawyer since 2005. Today we are talking about criminal liability for non-payment of taxes in Russia. In Russia, one can be held criminally liable under two main articles. Article number 198 of the Criminal Code, evasion of an individual from payment taxes and fees, and Article number 199, tax evasion by an entity. In this video I will cover the following: what constitutes a crime, who can be held accountable, how such cases are initiated, what evidence can be presented by the investigation and thus how to defend yourself, what is the responsibility. 5. I will also tell you what options for terminating a criminal case there are if guilt is nevertheless proven. First, what actions form the corpus delicti, or in other words, in what cases criminal charges can be brought. Article number 198 and 199 of the Criminal Code state that evasion of taxes, fees and insurance premiums is criminalized. Evasion is considered failure to file a tax return, calculation or other mandatory documents, as well as the inclusion of deliberately false information in the tax return. In addition, there is another mandatory condition, namely damage to the state and a certain amount of unpaid taxes, fees and insurance premiums. Moreover, for the individuals and legal entities, this criteria is different. Individuals can be found legally responsible if the amount of unpaid taxes, fees or premiums is more than 2.7 million rubles. It's about $35,000 for the last 3 consecutive years. Legal entities, or rather their leaders, can be charged if they didn't pay taxes, fees or insurance premiums in the amount of more than 15 million rubles or $200,000 for last 3 years also in a row. If you don't pay taxes on small amounts, you cannot be found liable. Number 3. Crime committers under Article number 199 of the Criminal Code may be considered the head of the taxpayer organization, the chief accountant, whose duties include signing the report and documentation files to the tax authorities, as well as other employees if they were specially authorized to file tax returns. These very individuals will be held criminal liability in case of non-payment of tax. Here the job descriptions of the chief accountant are important. If everything is obvious with the leader, because he or she must manage overall operations, then to hold the chief accountant liable, the obligation for signing and filing reports must be written to their job description. In addition, he or she themselves should, let's say, take the file. How are such cases initiated? Since March 2022, the basis for initiating a criminal case in such cases has been the material sent by the tax authorities to the investigative committee to resolve the issue of bringing a criminal charge. As a rule, the case file already contains the employee's testimonies given to the tax inspector, written documents and other information obtained by the tax inspector during a desk or field tax audit. What evidence supports the acquisition and how to defend yourself? Firstly, the main base is, of course, the tax audit materials collected by the Federal Tax Services. Second, on the basis of these materials, the investigator interrogates employees of the enterprise about the actual work performed and services provided, demands contracts, invoices, way bills. To do it, the investigator can go to the place to inspect the place where the goods are stored, the works was carried out. If necessary, face-to-face confrontations are held between employees if their testimony differs. This list is basic but not exhaustive. When defending in such case, it is necessary to provide reverse evidence, documents and testimonies of the actual performance of work and provisions of services, the supply of goods, and in the general the existence of expenses due to which the taxable income was reduced. What is the liability for the tax crimes? For non-payment of taxes by an individual, liability is provided in form of imprisonment for up to 3 years if the amount of unpaid taxes is more than 13 million rubles for last 3 years. The punishment for responsible persons in an organization is slightly higher, namely imprisonment up to 6 years. How already initiated criminal cases are terminated? There are two bases. First of them, all debt has been paid, and second, the statute of limitations for prosecution has expired. So first way is to pay. Termination due to payment. A person who has committed such a crime for the first time is exempt from criminal liability under two conditions. The arrears and the corresponding penalties and a fine have been fully paid. Besides that, on March 18, 2022, the President of Russia issued Law number 78, under which, according to tax evasion reports, the investigator must now simply refuse to initiate criminal case. Second possibility to terminate the case is termination of the criminal case due to the expiration. The statute of limitations is the period within which a judgment must be passed. If an individual or an legal entity fails to pay taxes in the amount of up to 45 million rubles, the limitation period is just 2 years. This means that if the court doesn't issue a verdict within 2 years from the date of filing an incorrect tax return, the case is simply terminated. While in relation to the responsible persons of an LLC, when the amount of unpaid tax is more than 45 million rubles, the limitation period is 6 years. I hope this information will help to you in your litigations with tax services. My name is Vasily Tarasenko, I'm a Russian attorney. If you need help with tax cases, you can contact me. Don't forget to subscribe. I wish you good luck. Bye.